Hello, my name is Mike Stevenson from Witness Drafting Services. Today I want to talk to you about how to draft a witness statement in relation to an asbestos claim. Now this is something of a whirlwind guide considering how much you need to know in relation to how to draft such a witness statement, but hopefully what I'm able to do is just cover over the basics so you just have a grasp of what you need to do. Um, there are lots of claims in relation to asbestos at the moment. That's due to quite a bit of a lot of people being exposed to asbestos in the past, and due to the latency period, that means that it is starting to come to the fore with a greater number of asbestos claims. So you may wish to consider, if you're in practice, asbestos claims at the moment. In asbestos claims, it is quite usual to disclose the witness statement at an early stage because this is essentially your client's evidence, and to help the insurance company on the other side establish whether there was exposure to asbestos and whether that was sufficient for them to consider a payout in relation to your client's claim. So it's important to try and do the witness statement as soon as possible and as detailed as possible, so that it can be sent to third-party insurers, because essentially you don't want to be trigger happy with issuing court proceedings, because ultimately may well shorten the time frame that you have in order to gather all the evidence together to make sure that your claim is properly presented. Your client must prove and balance the probabilities that for each employer that he is claiming against that there was sufficient exposure to asbestos. So it is important that this is set out within the statement. As an aside, you also need to make sure that the correct defendants are detailed within the statement. There's no point in putting the incorrect employer down and finding out later on down the line that it's the incorrect employer, because ultimately you're going to have to rework it and clarify who the correct defendant is, so that you are proceeding against the right employer and also the correct insurer, when at some point you may already have a claim against other defendants, so you're almost playing catch up in relation to one of the defendants if it's not the correct one in the first instance. If you already have the medical report at this stage, then you should know what the asbestos condition is and also whether it's divisible or indivisible. For example, if you're making a claim in relation to mesothelioma, which of course is an indivisible claim, you may be tempted to focus on one employer. However, you need to make sure that you cover all employment periods within the witness statement, because the third-party insurers may want to consider a contribution from one of the other employers, and in addition, you need to consider that maybe the third-party insurers may have a medical expert who states that it's not mesothelioma, and therefore it would then be a divisible condition. So you need to make sure that your witness statement fully covers everything you need in relation to every employer that he worked for. In addition, your employer may also row back in relation to his own prognosis. So you just need to be sure that you know exactly what you're dealing with, and making sure that the witness statement is as full as possible in relation to each employment period in case of any eventualities. In relation to duty of care, of course, each employer owed a duty of care to their employee in relation to any asbestos exposure. So you need to know whether whether they did expose them to any asbestos. So that asbestos can be found in many places within the workplace. It could be within architects' ceilings and walls, in soffits and fascias, internal wall partitions, ceiling tiles, floor tiles, heating cupboards, boiler houses, within pipe lagging, toilet cisterns, stair nosing and electronics. So there's lots of places that you could find asbestos, so you need to find this information out from your client. What was he actually dealing with? What were the materials he was using? To that end, you need to make sure that you go through the HMRC schedule with each employer to make sure that you know whether there was exposure to asbestos with each employer and what that entailed. You need to ask, what was the employer called, where were they based, and did he work on the site, such as a factory, or elsewhere, such as on a new housing estate. You must show within the witness statement that the exposure likely caused the condition. So it's important that you go over each element of each exposure in relation to the nature, extent, duration and frequency. That's nature, extent, duration and frequency. You should consider the regulations and guidance notes in relation to the exposure. For example, EH10 in 1976 replaced TDN 13, which covered what the employer should be doing, which basically said that it was the employer's responsibility to try and reduce the level of exposure to asbestos. Even where it was a small amount, they were expected to show that they were reducing exposure. So if they weren't showing that they were taking any steps, then obviously that would make your claim a little easier. In relation to date of knowledge, it is important to establish when the exposure took place and also the size of the company that who was the employer at the time. For example, if they were a large company in the 1950s where the exposure took place, then you would have a better chance of establishing that they knew that there was a risk to asbestos exposure, which would give you a better prospects of showing that they would have known, whereas a small company in the 1950s would be less likely to know about that, which obviously would make the claim harder to prove that they would have known and would be liable. So these are other things to think about when you're drafting the statement. One way that you may be assisted with this is to ask your client whether he knew of any other employees at the time who were exposed and whether they made a successful claim. So it's worth getting in contact with them just to show to the third-party insurers that yes, that there was another claim and to establish if they have been successful, then of course your client's claim should be successful as well if they were doing something very, very similar. In any event, it is worth obtaining a witness statement from that other previous employee as that will help evidence the exposure that you're dealing with. Also bear in mind that if you think you're dealing with a small company, then there is a possibility that there might have been a subsidiary of a larger company. So it makes it a little easier then to prove that they should have known what they were doing at that particular time. That it might be that the bigger company would have provided guidance to the smaller company, given that they form part of a larger company. You can ask your client what he believed the employer knew about the asbestos exposure at the time. For example, were there any warning labels on the sacks that the asbestos might have come in? That might have been a clue for the employer. Were they given any training in relation to that asbestos exposure, and was that training rigorously enforced or at all? The later the exposure, the more likely the employer would have been expected to have known about the risks. For example, there was the Thompson and Newhouse paper, which was reported in the Times in 1965. This was a watershed moment, so it would readily have been expected that if you'd been exposed to asbestos after that time, then really the employer should have known of the risks associated with that. In relation to causation, you need to show that each employer materially contributed to the condition, and also the source of each exposure and the fibre mill generated would have been sufficient for the exposure to have contributed to it. Now I'm going to come on to how to prepare the witness statement. In relation to each employer, I would view it as almost like a tree with different branches on it, where you need to cover on each exposure with each employer and each contract and subcontract through the duration of each employment, the nature, the extent, the duration and frequency. Also, in addition, the protective equipment they use and any training that they received. So each individual employment and subcontract within each individual employment, you need to do a tick box exercise to make sure that every single one of those is covered, to make sure that you're fully presenting a full description of that exposure, so that the insurers can consider whether that dose was sufficient. In relation to the nature of the exposure, you need to explain the process. What was being done on a specific thing in relation to that exposure to asbestos. You need to consider what was the type of exposure and the material that was used. Was it, for example, brown, blue or white asbestos, which obviously can affect the dose calculation at the end. For example, the white asbestos has caused a lot less deaths than blue asbestos. So you need to, although you may not know specifically whether it was white, blue or brown, you need to know specifically what the material was they used, so that it can be considered later on whether it was likely to be white, blue or brown, which will give a better idea of what the dose was. Examples of white asbestos are, for example, insulation boards, gaskets, joint, compound, roofing materials, cement, brake pads and brake linings. Brown asbestos, for example, would be insulation boards, roofing products, tiles, lagging, thermal insulation, fire protection, plumbing insulation, cement sheets. Blue asbestos would be brown insulation, fire protection insulation boards, thermal insulation, electrical or telecommunication wires and ceiling tiles. You need to understand exactly what your client was doing so that the process is understood. Was what he was doing at the time plausible to you, and was it the industry standard that he was doing at the time? It is important to know that one asbestos product could have significant ramifications on the dose calculation when compared to another asbestos product. For example, if it was exposed to blue asbestos, even just a small amount, then that is going to significantly ramp up the dose calculation as opposed to white asbestos. So it's important that within your client's witness statement that you know exactly what you're dealing with, or if you don't, then as descriptive as possible, so that an expert or the third party will have a better idea of what it was that they were dealing with. Here are some other examples that you need to consider asking your client when you are going over the witness statement with him in relation to delivering asbestos insulation board. Was it in cut pieces, or was it the manufacturer's standard size sheets? If it was already cut, then there would have been greater asbestos fibres flying about, and obviously that can affect the dose calculation. In relation to sawing, was it with a hand saw or a machine saw, and was there effective exhaust ventilation as well? You may also want to ask your client if there was any sawing involved. Did any fibres end up on the floor, and how was that dealt with? Was it swept up? Was it dry swept, or was it dampened down? Which obviously can have an effect on the dose. If it was dry swept, then there would have been greater exposure, which can of course vastly increase the dose, and the expectation that your employer, there would have been an expectation that the employer would have asked their employees to at the very least dampen it down, but if they didn't do so, then that would give you a better opportunity to succeed. And also consider if there was any delagging taking place. Was the lagging given a soaking beforehand for exactly the same reasons? Obviously, if it remains dry, then there's going to be greater dust particles given off, which obviously increases the dose. In relation to Artex, you may want to see if there was any other exposure at the time due to the small amount of asbestos within Artex products. If they were mixing it, then that might have been over for a very short period of time before the water was put in, and obviously at that stage there might have been less fibres given off. So if there was exposure to Artex, you need to see if there was any other exposure with any other asbestos, which would assist with the claim against that employer, because it's quite possible that the employer or the insurers for the employer may reject the claim otherwise. In relation to removing brake linings, there is an argument that if there is asbestos within it, that once it's been heated up to a certain temperature, then it may no longer be hazardous. So you need to consider whether, if you're bringing a claim in relation to the removal of brake linings, then you need to consider whether you really want to run that, and if there was any other exposure to asbestos with that particular employer. So that is something else to consider. Another key point to consider in relation to each potential exposure to asbestos was there any secondary exposure? For example, were there any other people working nearby who were dealing with asbestos, and potentially those fibres could have made their way towards your client. Also consider whether that was outside or indoors. Obviously that can have an impact on the dose calculation as well. As a guide, a 20 feet distance may reduce exposure by 90%. A 10 feet distance may justify a 50% reduction from exposure at source, and a 1 to 6 foot will be a reduction of the dose, but it wouldn't be a large one. The next step is to go over the other areas. So first of all, we've already dealt with the nature in relation to the process. You need to consider the extent, duration and frequency. The problem is if you only focus on the process, the nature of that exposure, then it's likely that the insurers will either ask for additional information, or they will just reject the claim, saying that the claim is unproven. So it's important that as early as possible that you cover the other areas as well. In relation to the extent of the exposure, you need to consider what was the extent of the exposure each time. For example, were there clouds of dust, or was it just hand drilling into asbestos board? Was the exposure inside or outside, where the exposure would quickly disperse? Were there any other trades there, for example on a housing estate, who were dealing with asbestos, and if so, what were they actually dealing with? How often were they there when they were dealing with it? And how in proximity to your clients were they? Given the type of exposure, you need to consider what was deemed to be the safe level of asbestos exposure at that time, based on the guidance notes. And was your client over that threshold at that time? For example, TDN 13 in 1970 stated that there should be no more than 10 minutes exposure of 0.2 fibre-mil of blue asbestos, but that's 2 fibre-mil for 4 hours, or 12 fibre-mil for 10 minutes for the other types of asbestos. So to consider the extent further, for example, drilling into asbestos board, was this using a handsaw? The number of holes that were drilled? Was the work outside? In this scenario, you may find there is not sufficient exposure, but you may want to ask him whether there were any others around him who were doing the same job. Was the area swept up afterwards? And if so, did it lead to asbestos being kicked up into the air? Was it dry or wet, swept? I.e., was water put on it first to prevent it going up in the air? So far we've dealt with the nature and extent of the exposure. Now we need to deal with the duration. So how long was he doing each individual process for? You also need to consider whether it was over 3 months or 2 years within that employment period. You also need a detailed breakdown of the tasks that he was doing and the duration of each task, so the level of the exposure can be established and can be compared with what the levels were in common at the time. Insurers are likely to ask what your client was doing on an average day. So if you can get a detailed description of an average day in relation to exposure to asbestos, what that would be, but obviously leave a little bit of wiggle room in relation to those days where there may have been more or less exposure, just so that you can give a bit of a flavour for a typical day, and also periods where that might have been more or slightly less. If you don't do this, for example, then you may get Part 18 questions from the third-party insurers who want a bit more information in relation to this. So if you want to try and settle your client's claim as quickly as possible and as effectively as possible, then if you can get this information in the first instance, then it will make life easier for you and your client later on down the line. So far we've dealt with the nature, the extent, the duration of the exposure. Now we need to know about the frequency. So for example, you need to consider how frequent was it that he was exposed. Was he doing it, for example, for a 2-month period within an employment, and then he might have been elsewhere doing it? And what about if they were a delivery driver? Were they delivering asbestos, or were they going to a place where there might have been asbestos exposure where they're going into the factory and speaking to people. It might be that they only did that delivery once a week, but they might have been in there for half an hour each time, or were they making that delivery every day, or every 6 months. So once you know the frequency, how often they were doing it, then that can help with the dose calculation with the insurers. Next, you need to consider in relation to each exposure, what training was he given, and was that enforced, and was he given any warnings? Were there any signs on the walls about the dangers of working with asbestos? Were there signs on the walls, or were they within his documentation he was given, or parts of the training? So these are things you need to consider. The next thing you need to consider is in relation to the protection he was given in relation to that. Was it satisfactory at the time? What was the guidance note at the time that the employer was expected to follow? Was it satisfactory in accordance with what that said? And was there enough of a risk for those precautions to be taken? You also need to ask your client in relation to whether the factory inspectorate ever attended the factory where your client worked. What was the outcome of those visits, and did it lead to any other training for your client or the other employees, and was that enforced afterwards, or was it quite slack? The next thing I want to cover is in relation to your client's injury and also his losses. Once you've got the medical report, it should explain what the condition is that the expert has given a prognosis for. If you're dealing with mesothelioma, then it is very important you get a medical report as soon as possible, given that if the expert has said that that's what the condition is, then your client may only have 12 to 18 months to live. So it's vitally important that you obtain that witness statement as soon as possible, so that you're not having to rely on family members or the co-employees, even if they're still around at the time. You need to set out when he first noticed his symptoms and what he did about it. This is in relation to dealing with limitation, which, although it's not quite as hot a topic as it is for noise-induced hearing loss, you still need to cover this. It's quite likely that if they suddenly have breathing difficulties, they are going to go and speak to their GP about it. And because of the latency period, it's not like noise-induced hearing loss where it gradually gets worse. They may be symptomless for 30, 40, 50 years and not know about it. Suddenly they may be breathless. So you would kind of expect them at that stage to go and speak to their GP at the moment. So you need to consider that and what further investigations were done at that stage. In relation to their condition, you need to consider how has it affected their day-to-day lives. Has it stopped them from doing something they had planned? For example, if they used to be a builder, they might be considering putting an extension on the house, and maybe they need to find someone else to do that for them. That's just an example of something that they might have wanted to have done that they can no longer do. Have they had to have care and assistance? Quite often this is the case, so it's quite important that you also obtain a witness statement from the carer, although in some instances insurers may not necessarily insist on that. They would be reserving for an amount for any care, particularly in relation to a mesothelioma claim, something like that, where they would readily expect that care would be required. In addition, you need to consider has it affected them in relation to not being able to go to work. So potentially they also have a loss of earnings claim, which you need to detail within the statement. You can then put in the medical report the detail in relation to when you went to see the medical expert and what was the prognosis of that. So that might be mesothelioma, pleural thickening, asbestosis. Of course, pleural plaques is only compensatable in Scotland. So as long as you set out within the medical report briefly in relation to that visit and what the expert said. It is important that within the witness statement it is entirely consistent with what the medical report said. So you need to make sure that any exposure to asbestos is the same within the statement as it is within the medical report, and vice versa. For example, he might have told the medical expert something slightly different, and he might have detailed that within the medical report in a slightly different way, which obviously could then affect the prospects of the claim or the dose calculation to establish whether there was sufficient exposure to a particular employer. So it's important that if there's any inconsistencies, that they are ironed out before you disclose the medical report and or the witness statement. You need to consider within the medical report the disability score that the expert has given, and speak to the client about how he's found what he's doing on a day-to-day basis, how that's affected his tasks, and whether that is getting progressively worse. For example, in a mesothelioma claim, you expect, for example, every 3 months you're almost in a different phase of struggling with what to do. So obviously you can only do it up to the point that you're doing the witness statement, but to get a detailed explanation of what they're struggling with, and potentially what they're struggling with 3 months ago, what they're struggling with for the last 3 months. Obviously you can't explain what will happen in the future, but you can give a bit of a flavour of what is anticipated. Other losses to consider are in relation to the care that is received, which you've already covered, in relation to the dependents. Obviously, if he's no longer able to work, then that can have an impact on those dependents that are relying on that. So it's important to detail that, and also if they're old enough, potentially get a statement from those dependents. You also need to consider the situation in relation to the CRU, because obviously some of that can be knocked off the compensation. So as long as it's clear how much they've been receiving, then that would be the best thing to do to detail that within the witness statement. In relation to loss of earnings, consider whether they have had to stop working as a result of the condition. Obviously you need the details of their earnings from the last 3 years. Are they close to retirement anyway? And if they were intending to carry on work, then you need to detail why that would have been. If they're self-employed, has someone else had to take over the work from them that they were planning on doing? And if so, it might be worth getting a witness statement from that person as well. If the person you're dealing with has passed away, then it might be that the estate wants to bring a claim on their behalf. So it's important that you have a look at the death certificate and autopsy report, if there is one. If that shows that there is the cause of death was due to the asbestos exposure, then obviously that puts you in a position where you may be able to bring a claim. Obviously that needs to be evidenced, so you need to consider, are there any employees that he would have known that could give you a statement to help you with that, or are there any family members at all that can remember the processes that he would have explained to them about how he was exposed. Other examples might be that he came back and his overalls were completely covered in asbestos powder when he got home. So these are important things you can add to the evidence to assist a claim in relation to someone who's passed away. Thank you for watching this video in relation to how to draft a witness statement in relation to an asbestos claim. I intend to do follow-up slides in relation to this for training. So if you want to have a look at my LinkedIn page or on Twitter, I should be making that available within the next few days. So you'll be able to find that if you were to Google witness drafting services. That's witness drafting services. So thank you very much for watching today's video. I hope you enjoyed it and found it informative. Please give me a thumbs up like on YouTube, and I'll see you for the next one.